Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his service love you.
Is that correct?
Literally not true. Oh, for Trump's sake. I didn't ask you to interrupt me.
Alrighty, welcome back to the Court of Public Opinion. I am the Recovery Addict. Still trying to figure out how I want to organize everything over here. All right. We'll let the music play out here. We've got the music on the slider now instead of on the switcher. But when the new camera comes, we'll fix everything. We can hear you. That's a plus. Mel Boy, I'm going to credit that to the fact that you are in fact running the internet. Yes, you are the internet owner for this afternoon. Congratulations. First in chat, we're sentencing you to internet ownership. Are you going to get a bigger desk? I need to. The music is on electric slide. It's electric. Yes. Yes, it is. And off. All right. I love hearing you complain about not having enough space. I'm a data hoarder. I like having 50 terabytes running out of my basement. I have, you can see over here, you can't see it very well, but I've got, this is my Blackmagic Cloud Dock interface, like right here. See that? With every little purple dot that you see on the screen represents 0.7 gigabytes. That's the cell size. So that is 4 terabytes of space represented. So I'm monitoring. I can probably fill that up in 2 days easily with what we record during the day. And then I use that for playback on my slow-mo machine. Anyway, we're going to continue this afternoon with a little bit of court watching. It's a couple fun things are happening. We've got a judge right now that we haven't seen before that is doing judgy things.
And no to attempt to set it into December. That gives us plenty of time to hopefully for the courts to hopefully get their systems back up and running, and we'll get a date. But based off the defense request for continuance, it's an excluded period, and dates to be set by the court. With defense has no objection to that.
Okay, so no objection to moving the trial date, and we'll just set another confirmation date.
Apparently their system is down.
And you're looking for early December. We'll make a note of that's your request. And do you have Edwin Diaz's contact information for the court?
I do, Your Honor. Give me just 1 sec.
And if it's the Columbia address, I can send that to the clerk.
The Columbia address?
We have a different address.
This is Thurston County.
I think it's been updated. It's 7714 Northeast 39th Court. And that's Vancouver, Washington, 98665. We'll also make sure that both of our clients are apprised of their next court date when we receive notice, Your Honor.
All right, perfect. All right, thank you, Mr. Newcomb.
My pleasure, Your Honor. That's all I have. Am I excused?
Yes, you can go home now.
Thank you. Have a great week.
During lunch, I was watching Judge Fleischer a little bit, and he was jumping in chat. He was saying it's almost
in the courtroom here.
It's almost fortnight time.
My client is Diana Zuniga, who now should be on the Zoom. We communicated. She said she got the link and was able to enter into the.
All right, Diana Zuniga, if you could hear me, if you could unmute and turn your camera on.
Bing. Hey, Diana. Welcome.
All right. Good morning.
Good morning.
So, good morning, Your Honor.
Good morning.
This is a slightly, well, Unfortunately, the procedural history here is a little masked by the necessary confusion related to the hack of the judicial systems. I believe we're at pretrial. We waived arraignment.
They got hacked.
I believe my friend on the other side has this noted as an arraignment. I can tell you, I know for a fact on September 30th, I filed a waiver of arraignment and notice of appearance, and this is a driving third offense. So I would imagine that would waive arraignment. We'll verbally waive arraignment here because we're allowed to. But we do need to deal with conditions, and I know my friend has some conditions he's asking the court to impose that we're absolutely agreed with. So I would just ask that we take conditions. We'll enter a not guilty plea for the record, understanding we believe we've already done so. And then I just ask that we set some sort of future date, understanding that the court's not going to be able to give it to me right now.
And are you stipulating the probable cause as well?
Yes.
Okay. All right. Well, that's how we can proceed then. Mr. Thompson, what is the state's assessment on conditions of release?
We just asked the court to impose standard driving conditions. We're not requesting bail at this time.
Okay.
So no drive without license or insurance, no criminal law violations.
All right. Any objection from the?
My client understands that's already an accurate statement of Washington law, and so we have no, I think, legal basis to object to those conditions.
Points don't work. I mean, it still responds, but we are not running points.
All right. Well, Ms.
Really
Zuniga, that's what we'll do. I'll release you on your own recognizance today. Or not. What that means is that you won't have to post any bail at this time on this charge, and the conditions that you'll be under while we get a new court date. While this case is pending, is you not have any criminal law violations, and that you not drive without a valid license and insurance. Maintain contact with your attorney, and appear at all court dates. And we need to verify your address or get your address from you today, because we're going to send you in the mail copy or telling you when your next court date is going to be. We can't get that to you today. So what is your mailing address?
It is 123 Sesame Street, right next to Oscar the Grouch. And just put any zip code 12345.
98338. Okay.
There we go.
Okay, and we will mail notice out to that address about when your next court date is going to be.
Okay.
Sounds should be working. Are they not working for you? Let me quit and restart them.
Was it 249th court?
245th.
46th. Okay. Thank you.
Fifth. Yeah, I think 245th.
245.
Thank you.
Third time's a charm.
It's okay, Judge. We've all had those days. I'm having one now.
All right. You are free to leave the Zoom platform, and thank you, counsel.
Thank you, Your Honor.
Thank you.
Mm-mm.
All right.
Store chat, pump out chat. When a court system gets hacked, it causes mayhem.
All right. Looks like we have counsel ready.
They have no idea what they're doing.
Christian Valdez Goodwin.
Morning, Your Honor.
Papers everywhere. They can't check any documents. They can't verify anything. Thank you, sample user. I think seats should be working now. Commands should be working.
Valdez, it's on the number 7 on 10.
Ooh, buttoned up, checker shirt.
Christian
looking
Valdez,
proper.
Goodwin. All right, looks like we're here. Can you hear me okay, Mr.
Must
Valdez?
be a huge
Goodwin?
door behind him.
Good morning, Your Honor.
Okay, good morning. Looks like we're here on a confirmation of trial.
And defense has sent the state and the court a waiver of speedy trial, new commencement date of January 7th, with an expiration date of April 7th. I just forwarded that to Madam Clerk, signed by Mr. Valdez Goodwin and Mr. Arbenz. Sorry, counsel, for stealing your thunder.
That's completely fine, Mr. Thompson. And for the record, Attorney Naran Bates here on behalf of my colleague, PCR Benz today, and that is all correct information.
Okay. All right, Mr. Valdez Goodwin, any questions about your speedy trial waiver this morning?
No.
Okay. Well, we will continue this matter. We need to verify if you could give us your mailing address today, and counsel, if you could send it on the chat if you want, or we can have your client give it to us verbally. Either way, we just need, our computer system is down, and so we need to make sure that we have a good mailing address for you, because we're going to send you in the mail a copy, or telling you when your next court date is going to be.
It's all right, Christian, if you want to provide the address.
Okay. Yeah, my
address is 1234 567th Street in Thurston County. The zip code, whatever. Okay, there we go.
And that was road.
Judge, you don't have to repeat it. Okay.
9850.
Zip code
98506.
Okay. Thank you. All right. Well, we will mail out notice of your next court date.
Together, weird stuff happens.
All right. Thank you, counsel. Thank you, Mr. Valdez Goodwin.
Yeah, turn off your other videos you're watching.
Thank you, Your Honor. Thank you, Ms. Johnson.
So Thurston County got hacked. Their judicial system computer network is down. They've gone old-fashioned, trying to work with paper, which means a ton of work for court staff, which normally is automated or at least electronic. It's terrible. This happened to where else? In Georgia. Judge Manning. Their system was down for like 2 months. They got hacked, and it was one of those ransomware viruses where they said, we've encrypted all your data. If you want the key to unencrypt it, it's going to cost you X number amount of Bitcoin sent to this address. And I don't know if they paid or not, but they're back up. When a court gets hacked, martial law is instituted. That would be terrible. Let's see.
Your Honor, there was a tracking infraction on Walters. I don't have the cause number. Madam Clerk can give it to you, but the state would move to dismiss that tracking infraction.
A tracking infraction.
Yeah, 4A0638861. The court will dismiss.
Yeah, they're terrible hacks. They really are. They work their way in through any way they can, and if they get access, they just encrypt key files, and your business is crippled.
Morning, Your Honor. You have something ready?
Yes, I have Mr. Collins on the docket today. I believed he might have been hiring a private counsel, but I don't see him or his counsel. So,
that was Collins. What time was that? Oh, there. Okay, Collins.
Harris Collins. Yes.
And what do you think is the status that they were hiring their own attorney?
When I last spoke to Mr. Collins a couple of weeks ago, he said he might be hiring his own counsel, which is why I think he's on this docket. I said, well, if you do before then, that's fine. Just have them show up. He does have a plea offer on the table, and I've had pretty good contact with him. So I'm not sure why he's not here. I did send him a text earlier.
Do you have his mailing address with you? So we'll probably end up doing is setting another.
Okay, we're gonna have to bail on this one. They just keep giving addresses constantly.
That would be my request, Your Honor.
Okay, we're gonna bail on that for right now. They keep giving addresses, and that doesn't help us in the slightest. It's the one thing we just do not want is personal information from defendants. Let's go see. Judge Fleischer was working. Let's see. Josh, I see you sent me another link. Stepka. Let's take a quick peek. Judge Stepka. E5 up there. Okay, let's see what these guys are doing.
Mine was. That's why I'm wondering why we're the only two here.
The judge is not.
You got
here.
notices twice.
They're waiting for the judge.
There's your client.
I might back up just a little bit. The judge is not. The court's not there. Let's see. Waiting for when they pop in. It's just a couple minutes ago. We get to hear these guys talk to each other a little bit, waiting for the judge. There we go, right here. Uncivil Law says, hello, I've been trying to reach you about your car's extended warranty. I'm sorry, you're breaking up, Kurt. You're breaking up a little bit. I don't buy warranties for my cars. I might be alone here, but I do not buy a warranty. When you're selling me a product, okay, and you charge me literally thousands of dollars for that product, and you go on about how amazing it is and how it will solve all my life's problems and I will be so happy with it, why, as soon as I say yes, do you then turn around and try to tell me how quick it's going to break? It's like, no, I'm still on the old, you sold me on the other pitch, how wonderful it was. Now you're saying that, oh no, guess what? As soon as you drive off the lot, this thing's going to fall apart. One of them was a lie. And I just bet on the second one. So I don't do the car's extended warranties. Finance guy is different than the sales guy. There were lies. The only way to solve all your life problems is by subscribing to Uncivil Law. I've done that. And I've found myself better for doing it, Kurt. Although today's been a little hectic with equipment going down. It's just forced an upgrade faster than I thought I was going to do. But now on new equipment today. And we'll get it pieced together. A day at a time, we'll get better. I did get, I heard over lunch, I heard Mrs. R.A. saying, oh, just what I wanted. More cables, which means that she opened up another package that came for me, which I believe is a felony, right? If you open someone else's mail, isn't that a felony? Anyway, so I got 6 more cables, which I needed. I needed more cables, not these ones. There were other ones, but these ones came yesterday. So 6 more. These were USB-C to USB-C cables, and I quickly went out and rescued them from wherever they were going to end up. All right, waiting for the other attorney to show up so we can hear the dialogue, as the court is not there, but the Zoom room is open. Let me just give him just a minute here to show up, or I might fast forward. It was only like 2 or 3 minutes. There, let's see. There we go, right here. Key sunsets for life. Sarah Boone has filed papers for neutral. We read those in our last stream. They're crazy. Some of them we expected.
David.
Howdy. I had one of those moments where I opened my Zoom and it says, oh, you need to do an update or this isn't going to work. I'm like, great. Good thing it only took 2 minutes.
Yeah. Well, how are things going with you?
I'm a little nervous.
Yeah, well.
I mean, I'm on the ballot in my township. I'm not so much nervous about that, but the whole thing's, I'm a little anxious.
They're talking politics.
I think you're not alone.
So I'm not going to get any work done. I might as well go home after this.
So how long before you think we'll actually know?
Everybody's talking politics.
Sometime tomorrow?
Pennsylvania took 3 days last time, I think.
Oh, did it? Yeah.
You know, Florida does it all before 10 o'clock.
Don't make me mute you. Don't go political on this.
My wife's an election worker at Blair Township. So she worked 3 days of the early voting and all day today, you know, till midnight, whatever.
Yeah.
Keep it neutral. Keep it neutral.
But early voting did take a big chunk, 40% or more of the voters.
Mm-hmm.
So what's happening is these 2 attorneys have shown up for
So
court.
how
Judge
many
is not
board
there.
members in Green Lake are up?
Well, they're all up with the president every year. So there's 8 people running for 4 slots. 4 Republicans, 3 Democrats, and 1 independent. So normally the 4 Republicans get in. Democrats don't usually do very well in my township.
Yeah.
But who knows?
Pickles, not politics. We're waiting for court to start.
It'll be my 5th term. 5th 4-year term.
Why aren't you running for supervisor?
Who wants that job? Nobody wants that job. I mean,
Well,
clerk is worse, but
yeah. Oh God, yes. Wow.
oh, Marv Radke is supervisor.
Yeah. No, I know.
He does a really good job.
Yep. Yeah, I think the worst job in the township may be the planning commission chair.
Well, you can't find people to sit on the planning commission that know anything.
Yeah.
I represent the village of Kingsley. I think they're going to have like 4 open council slots. Nobody's running for them. So there's a couple of write-ins. It's going to be weird. And that village manager just quit.
Oh, really?
She took a job in Ludington, I think.
I find it interesting that nobody else is here.
Like the judge.
I mean, I pulled up the notice, 1:30, November 5, got the right Zoom ID. So
maybe we can just
well, that's the Grand Traverse
plea negotiation
courthouse.
Yep. Which is probably where he is today, because I think last week was when he was in Bel Air.
We know at least one client shows up. So let's see what happens here. The courtroom is empty.
So have you heard anything from Jeffrey Geiger lately?
Should I?
I don't know. I got an email from Justin Willoughby the other day saying, Geiger's driving across my driveway.
Oh, yeah, I hear from Geiger. I thought you meant... yeah, he's... What is he doing? But no, not about the driveway. But he's been talking to township people about his development, whatever. I think they got a lot of turnover in East Bay, don't they?
You know, I don't know, to be honest with you.
They just stole our assistant assessor.
Oh, really?
From Green Lake. He left Green Lake to go to East Bay.
This is Pennsylvania.
He was also pretty much our zoning administrator.
Now, do they pay better in East Bay?
It's not that. Apparently, assessors need to have certain experience, and East Bay has more multifamily and weird stuff than we do. So he can be, was there 5 levels of assessing? It's crazy, but
yeah,
for him to go up the chain, he needs more sophisticated stuff.
I know they're building hotels in East Bay Township as fast as they can approve them. I don't know where the tipping point is, but I can't believe that all these places are going to be able to stay fully occupied or even half occupied.
Well, downtown too, the city's doing it.
Yeah.
When the client shows up, it's going to change the conversation just a little bit.
I don't have a secretary today. You're right, it is a little weird.
Well, I noticed your client logged on, and I know mine was. That's why I'm wondering why we're the only 2 here.
You got notices twice.
Here we go. There's your client.
Attorneys,
let's give them a few more minutes, and if we don't see any movement, I'll have Colette call the court, find out what's going on.
Melissa, that's great to hear. Got good news about Jules today as well. Things are going well with her.
So Josh, it's not unusual to not start on time, but it is unusual to not to see anybody.
Yeah, I've been watching for the last 15 minutes, and it seems awful quiet.
The attorneys are thinking, what did I say 15 minutes ago? Did I say anything bad? Did I say anything bad? Judge forgot he had court today.
Saw somebody's hand up by the bench.
Hello.
There he is.
All right. Hello. So good afternoon, everybody. So this is Torch Lake Township versus Joshua Burrows III as trustee of the Joshua L. Burrows III Revocable Trust, and Elizabeth Burrows as trustee of the Elizabeth Burrows Revocable Trust. This is Antrim County File 240205 ON3 involving 2 civil infraction tickets, 0204 and 0205. So this is the date and time of the court's decision. We had a lengthy hearing. This Wednesday will be 2 weeks ago. But to begin with, is there any additional argument the attorneys wish to make here?
No, Your Honor, I wasn't prepared to do any of that, so no.
No, Your Honor.
All right. Okay. So briefly, the facts of the case are that this dispute involves a shed that sits within the 10-foot setback on the Burrows property in Antrim County. Now, briefly, the Burrows, I guess when they purchased the property, there was an existing home or cottage structure on the property, as well as the shed. Apparently the shed's been there since 1981, has not moved. In any event, the dispute arose, late in 2021 when there was an application to demolish the cottage, and then there was an application along with a demo application to rebuild a home in place of the cottage. So the Burrows hired a builder. His name is Martin, hang on just a second, I think it's Martin Nemec.
This is a lawsuit over a tough
Martin
shed?
Nemec. And his business is Pleasant Valley Custom Homes. All right.
Not a sponsor.
To, I guess, do the demo and the the building of the new home. But Mr. Nemec is the one who applied for the demolition and new build permits in the case. The issue is, I believe, that Torch Lake Township states that along with or testified, and that's Jackie from Torch Lake Township. She testified that the applications came in with, let's see, a site plan, and there was some back and forth between her and Mr. Nemec on getting the site plan that she's requesting, but eventually it came in, and this is plaintiffs, I believe, exhibit Exhibit 4. Anyway, the issue is Torch Lake Township and Jackie, that she testified that the applications came in with this site plan that indicated that the shed on the property was to be removed. And Mr. Nemec testified, I believe, that he either didn't recall submitting that application or he submitted it and the plan he submitted did not have the shed to be removed. But in any event, the township is saying they had that document, which is referenced a couple of places here, Exhibit 5, and I'm looking at plaintiff's Exhibit 5-12. It's the 12th page on in Exhibit 5, which has the shed.
As much as I like the shed
on this parcel of property,
I'm trying to find another option for us.
and it indicates the shed is to be removed. And then Exhibit 8 also is 2 side-by-side site plans. The first has the shed there. The second one does not. These were submitted.
We're gone. All right. Sorry about that. The shed was just not interesting. I was hoping the judge would come in with a little more fire and vim and vigor, but he did not. It was El Lamo is what we might call it. It's important law. It is. I mean, to somebody, the ability to build a house and setbacks and town ordinances and building permits and everything, that means that's everything to them. But to us, it's not as important.
It will be true to the best of your knowledge and belief. All right, have a seat if you would and state your name for the record.
My name is Mike Lemax, Lemacks.
Ms. Davis?
Mike, where do you work?
K&D Body Shop.
And what do you do there?
I am Brian's general manager. I've
How
been
long?
there 29 years.
29 years, okay. As part of your duties, do you assist customers with getting estimates?
Yes, I do every day.
Okay, and do you keep the records of those estimates?
On computer, yes, I do.
Okay. Do you recall an estimate being done for a Page Curlin?
I do know Brian wrote that estimate. I did review it this morning.
May I approach her?
Yes.
If you recognize that packet
Yes.
of paperwork?
Yeah,
Is this what you brought with you today?
it is.
All right, and can you look through that, make sure that everything is as it was when you brought it in?
Yes, it is.
Is it a true and accurate depiction of the estimate that was made by K&D Body Shop?
Well, what I can tell you is Brian, as we always do, we write an estimate, how we think it needs to be written. We send it to insurance, and what you see in front of you is the revised edition back from insurance.
And so this is the most recent.
This is, yes, this is the most recent. This is where we would have to start the estimate to repair the vehicle.
Okay.
Through State Farm.
And the loss date is listed as 7/20/24. Is that correct?
I'm assuming yes.
Okay. And on the front page, there's a create date that it says 7/23/24. Is that accurate?
I do believe so, yeah.
Okay. So you're not, I guess I've asked to have this submitted as the People's Exhibit number 1.
Mr. Gibson, do you wish to voir dire?
We would leave this in the court's discretion.
Now, I know who you're talking about, but a couple of times you referred to Brian. Who is Brian?
Brian is Brian Kaiser. He is the owner of K&D Body Shop.
And you're his general manager?
Yes, sir.
And as general manager, you're in part responsible for keeping the records of K&D Body Shop?
Yes. I mean, pretty much any estimate that's written is saved in our computer database.
All right. Did you ever see this car yourself?
I have not. I just reviewed the photographs this morning and just went over Brian's estimate with the photographs.
All right, exhibit number 1 is admitted. It is a canceled customer request. It is 3 pages of estimate. And then there are several pages of photographs. 1, 2, 3, 4, 4 pages of photographs, and 4 pages of supplemental. So it's a total of 4, 7, 10 pages. And do the photos show some scratch damage to the driver's side of this Kia automobile?
That is what is shown here, yes.
And it goes across several panels of the automobile?
Yep, it looks like it starts on the hood
We went to a
and
court
goes
over
down
a
the length
Kia?
of the driver's side. Fender, both doors and quarter panel.
All right, so hood, front door, back door, and rear quarter panel?
Correct.
So 4 separate panels of this automobile?
Technically 5.
So the hood and the front quarter panel?
Yes.
All right. And what was your estimate after revision from the insurance company to repair this damage?
When we got that back from State Farm, it was a total of $2,956. Oh, I'm sorry.
Isn't that the price of a new Kia?
Or $2,998.90. Sorry.
And the customer had a $200 deductible with insurance?
That does look like it, yes.
But the damage repair estimate with tax is $2,998.90. Is that correct?
Correct.
So
All right.
$3
Exhibit 1
grand
is
to repair a
received.
scratch. I don't know what the lawsuit's over.
Like the pictures that are attached to this are black and white photocopies.
Right.
Did you look at like full color copies?
Yes, I did. In fact, that's what I brought in on the SD card for you today. It was full color.
And on those full color, they had a high definition type pictures. Could you see a pattern or any sort of
Just
marking?
kind of went, down the entire length of the vehicle.
May the record reflect he's making like a wavy
Yeah,
motion.
wavy motion.
His hand is doing this.
And you've been looking
got
at
keyed.
cars for 29 years of
Long
the damage,
time.
right?
Yeah.
Were the damages consistent with all kind of happening in the same time frame, or
They
could you see
look to be of all the same manner, they were all the same style of scratch down that entire length of the side.
And being that you've been doing this for a while, can you tell when some scratches or dings are not related?
The only time you can really tell, or you can date it, is if it went through the paint enough to hit the metal and it could start to rust, which would add, you could tell it's been a while, but I didn't see any evidence of rust on it.
No further questions. Thank you.
May I ask just to clarify
Yes,
one
sir.
thing? Just to clarify, you may have already explained this, but when it says on this written report, toward the very top under Brian Bird's name, it says create date July 23rd, 2024. Is that the day that you believe that Brian inspected this vehicle?
I do believe so.
Okay. Would we have to ask Brian if we wanted to know when he first was contacted by anybody regarding this vehicle?
Honestly, I probably should have brought it with me. There is a sheet that we do when people come in. We fill out their name, address, phone number, all that stuff, and we date it. And that's our basically our estimate sheet is what we jot down all of our notes to create this. That would have the actual date on it of the day she came in.
Okay, now would that also have, like, if she had called on the phone before she came in, would it indicate that?
It would not. It would not.
So if somebody calls, do you guys not necessarily make a record? You only make a written record if they show up, I guess you'd
If
say?
they show up, we make a written record, and then like say you come in today for an estimate, I jot down today's date, but I may not have time to write that estimate for 2 or 3 days, and that's when that date, creation date right there would show up. So it may be, maybe he looked at that a couple of days beforehand, or maybe it was that same exact day. I'm not certain right at this point in time until I look at that other sheet. Like I said, I should have brought that, just didn't think about it.
Okay, all right, thank you. I have no further questions.
Thank you. Thank you for taking time out of your day. You're free to get back to work.
Okay.
Thank you, sir.
Thank you, sir.
Ms. Davis, anything further?
No, Your Honor.
Mr. Gibson, any evidence your client wishes to present?
No, Your Honor, the defense rests.
All right. Evidence is completed. Ms. Davis, your argument.
This will sum up the case. It'll catch us up with
And I
everything we
believe that
missed.
there's adequate testimony to meet the probable cause standard for the one count of malicious destruction of personal property at 1,000 or more, but less than 20,000, regarding the damage that was done to the Kia Sorento automobile that is owned by Paige Curlin. The damage was done by Samantha Kelly, is witnessed by Savannah Hampton, who testified as to what she saw, what she heard. I think that the consistency between what she reported and then from what Ms. Curlin was saying, she confirmed it with the other adult that was there. The damage wasn't on her car before Charles and Savannah took it that day. And whether she saw it the next day or 2 days later doesn't really matter. It doesn't take away from the fact that we have a 9-year-old child who saw this happen.
My cat just caught and killed a squirrel.
As far as the amount of damages,
and is eating
again, from the testimony of the gentleman from K&D Body Shop, it meets the threshold for the 1,000 or more, but less than 20,000. And from the testimony of Ms. Curlin, there was no permission given to Ms. Kelly to do this to the car. She didn't even know that Charles was going to stop there. And it sounds like their relationship between these two ladies is not good. So I believe that there's probable cause to bind over on the malicious destruction of personal property, 1,000 or more, but less than 20,000. Thank you.
Thank you. Mr. Gibson.
Thank you.
The kids are traumatized.
I have concerns with the child witness as to whether or not she fully can understand the oath and is competent to testify. She did appear to testify today. I guess you could say she was able to answer questions. She did indicate quite a few times that she couldn't remember. I thought it was kind of a little bit odd that when she first was testifying, she wanted to make sure everyone knew that Samantha Kelly was upset by seeing what was inside of the car and being upset by, I guess, groceries being bought for somebody. And I guess that just seems odd that then she would go home and not say anything about this at all to anybody, like as far as her mother, or that the driver of the car would have not said anyone to anybody when this happened. I guess if the driver was watching this happen, was the driver in some way involved? I mean, I guess, I don't know, but the witness did testify. And so, I can't say anything that with the testimony that we have, it's in the court's discretion, but I would just ask the court to consider to make sure that the court makes all the considerations as to whether or not this witness is potentially someone that should be permitted to testify in this case. Thank you.
Obviously, I'll leave it to the court's determination of the ability of the child to testify and the competency of her to testify. I think some of the points made are just kind of out there. Dad told the child not to tell us what the child said. This is a child who is in a car belonging to her mother with her father, who is not supposed to be going to his other children's mother's home, but he did. And the car got keyed. And I don't think that's going to make for a great grilling cookout to get back and say, hey, just letting you know, my younger children's mother freaked out and keyed your car. Sorry. I know I wasn't supposed to go there. You didn't know I was going there. It makes sense why the child didn't say anything. It makes sense why Charles didn't say anything. So, as far as that argument goes, I think that the court has enough to bind over. It's happened in Three Rivers, St. Joseph County, Michigan, and it happened on or about the 20th of July, based on The information, I will be changing the complaint to make sure that it reflects that it was on the 20th.
All right, it is on or about, but it does appear that it was on the 20th. Ms. Kelly, as I told you at the outset, you don't get found guilty or not guilty at this hearing. It's a probable cause standard. And there was a lot of conjecture there and speculation in the closing arguments. It was outside the testimony, but it's reasonable based on what I heard. And I believe the reason we're not here is because Charles Hampton isn't here. If Charles Hampton saw what the child saw and what allegedly he told Paige Curlin he saw, he wouldn't be here. So he's probably on either both sides of the fence or not available. I'm not clear. But in terms of the credibility of the child, I thought it was very good. She's in the 4th grade. She's 9 years old. The court called dozens of children as witnesses when it was prosecutor. And I've heard dozens since I've been judge. I thought this child was very credible. She was relating something that she saw. Her story makes sense. Dad told her not to tell, puts her in between mother and father. She then kind of lets the cat out of the bag, and mother discovers that damage done by Samantha Kelly. I think a jury would believe this child. And then she had to get subjected to a cross-examination. And it's clear from the estimate of Candy Body Shop, which is a long-time reputable business in Three Rivers, that the damage is almost $3,000. You'd think a scratch of a car wouldn't be that much, but his testimony was it covered 5 panels of the car in a wavy pattern. So there's probable cause to believe that the defendant did it. It did occur in the city of Three Rivers, county of St. Joseph. There's certainly probable cause to believe that it was more than $1,000. So the matter's bound over to the circuit court. Ms. Kelly, your bond is in
We're
the
going to have a
amount
trial.
of $1,000 personal recognizance bond. I believe there is a condition of no contact with Paige Curlin. Let me look at the bond. There should be a no contact with Savannah Hampton.
Josh telling us the child testifying previously off camera in this hearing, the defense attorney was a total jerk too. Poor kid.
I won't be the finder of fact in this case. Someone else will be unless it's resolved somehow. But I believe the girl. Come on.
Did it have a note? Did it tell you not to have contact with more than one person?
Oh, no, it didn't say, but if that's the case, Savannah's at our house, I can really wait.
Well, there's no allocation that there's been any, but let me take a look. Darn it, this is frozen. Well, I'm going to shut it off and turn it back on.
For some reason, my computer won't let me log on.
I need that soundbite. Well, I'm going to shut it off and turn it back on.
I don't know if there's something wrong with IT or what.
This is the
Maybe you
Keep
did
Kia
something.
controversy.
Yeah,
It's going to go to
already.
trial.
Tony's leaving already. Things are breaking down.
Tony's leaving?
Yes.
Tony.
Well, darn it.
Tony, you've made the judge mad. It's the maddest I've ever heard him. I'm also watching for some other trials here at the same time. Okay, while he tries to figure out stuff, we're gonna jump back up to Thurston County, Washington. Just really quickly, District 3, Thurston County, Washington. Come on, where are we at? Thurston County District Court. All right, here we go. We've got a few people here. It looks like we've got Igor Shapiro, the attorney, Matthew Carlson, and David Myro, all present and accounted for. I think we have the requisite number of in-vehicle cameras, mullets, and hoodies on stream to proceed. I saw Ian's tweet. Amber, I think, replied to him. He was worried that it would be hijacked by all the political talk, and Amber recommended the same banned words we have on our channel, just for today, to keep all the posts about.
I know we're trying to limit the amount of probation time. Is this, Mr. Thompson, is this a case for monitored probation while they're on the SOC?
No, not on an SOC.
Okay.
Yeah, basically
Monitored by the court.
at 9 months, if there's been no violations, the defendant can petition for early termination.
Okay.
At the end of 12 months, if there's been no violation, or if the state's doesn't move to revoke, the case will be dismissed.
Okay.
The state and the court will just, I think, at the 12-month point, do a check file to see if there's been any criminal law violations, or anything related to, like, you got a speeding ticket or an open container ticket, then we might have an issue. But other than that, we'll check it on the back end, essentially.
Right. All right, Mr. Marness, I have signed the judgment and sentence. Do you have any questions this morning?
Not at the moment.
All right. Well, stay in contact with your attorney and make sure you abide by all the court's conditions. And in 9 months, if you've completed everything, at that point, you can petition for early dismissal of this. And if you, at any rate, at 12 months, we will review it. And assuming you don't have any other criminal law violations and have abided by the other conditions here, this case will be dismissed. Otherwise, we'll proceed the other way. But I will say good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. Shapiro. All right, Mr. White, are you ready on your matter?
And Your Honor, we are trying to get a plea form prepared to send to the court. It's done. I'm just trying to format it. It's crashing out my Adobe for some reason, so I just need a few more minutes to troubleshoot that.
Okay.
Oh, yes. Exactly. Thank you. Yes.
They're doing lots of paperwork up there. And Matthew Carlson is just waiting. I'm watching a couple other courts to see if we've got some funny moments coming up in any of the other live courthouses we like to follow. Sort of a quiet day.
Mayor, if I could just ask who the clerk is today?
Heidi.
I think that this version should be unlocked. If it's not, then I can tweak it to send an unlocked copy, but it should be unlocked.
Okay. Yeah, we're gonna print it out here, so.
And I appreciate the court's patience. Apparently, Jabs isn't the only thing that is having problems right now.
Yeah, it's probably contagious.
Well, it seems like Adobe sort of updated a security feature and made it so that the old workaround no longer is a workaround. So now I think I found a new one. So we'll just go with that.
Or you could just use the programs as intended. Okay, we're going to bail out as they've finally figured out how to run Adobe. And thank you, PNW, Pacific Northwest 4200. Appreciate that. I've got to jump over here to Donald Chisholm. Just 1 second here. Wish it were quicker to do it. Soon we'll get there. Magistrate Donald R. Chisholm. I think this is him, right? Channel. Go to channel. I think he's live right there. And we're going to back up just a tiny bit. just started this right here.
Court indicates that while operating a motor vehicle in the city of Berkeley on October the 8th at approximately 1:30 in the afternoon, westbound 12 Mile Road at or near Wakefield, you did operate said vehicle while holding or using a mobile electronic device. Officer, strike that. Sergeant Smith's remark on your ticket indicates patrol sitting stationary, observed driver pull up with phone in hand, driver continue driving and using phone in motion. So in essence,
it's the
he has
hands-free
alleged
violation.
a violation of Michigan's hands-free law. With that said, you have 3 options the court indicated to you. This is a 0-point violation. You may, if you wish, admit responsibility. You can admit and explain, or you can deny responsibility. We'll swear the parties and take testimony. What would you like the court to do for you?
I would like to admit responsibility, but also further explain, if I may.
Well, you may, but you, the court will need a confirmation because you're working with 2 separate branches of government today. So you're confirming you were driving a vehicle in Berkeley that place and time, correct?
Yes, and I did have a cell phone in my hand.
All right.
Wait.
Permit me to finish.
Wait.
You were operating a motor vehicle in the city of Berkeley, and you did at the simultaneous time operate a electronic mobile device, correct?
Correct.
Thank you. Court appreciates and accepts your plea. What would you like the court to know?
Well, a couple of things. I guess what I would really like you to take into consideration is, since this was my first time offense, if this could be a warning. So I drive a company vehicle. I've worked for my company for 25 years. And of course, I'm worried about my job and being on a list anytime something like this comes up. And I did go to the courthouse to pay the fine and was told that it would still end up on my record. So I was concerned about that, which is why I would like to bring it forward. To explain a little bit more of the situation, I am someone who follows the law and follows the cell phone policy probably more than most citizens. My company has had a cell phone policy for decades where my phone half the time has not even worked while driving a motor vehicle. I never have my phone in my hand. I don't text. I don't call.
Don't say never.
I answered a hands-free call. I was on the phone for 1 minute, 12 seconds, and I did have my phone in my hand. I am deeply regretful of that. When the officer pulled me over, I was so upset at myself for even having it in my hand like that, because I never do this, that I don't even know if I could really explain myself. Because I am the person who's lecturing everyone else in my family about this. So, of course, I would just like your consideration. Like I said, I spend all of my life on the road for 25 years with this company, and I've never once even been pulled over. So if you could please just grant this as a warning. And I have been an even better driver since being pulled over. I drive through the city of Berkeley as part of my territory almost every single day. And if you have any other questions for me, please let me know.
Thank you. The court senses that your mortification here is noted. The court doesn't have the ability to simply wade in and change branches of government. The court's here as the umpire. No idea what your driving record looks like. The court doesn't look at those prior to undertaking a traffic docket, but the court always welcomes the input from the citing officer. Sergeant Smith?
Your Honor, if I can make a motion to amend this to impeding traffic.
Okay. There's a motion to amend this to impeding traffic, Ms. Swigert, which is a 0-point violation and will never, ever appear on a master driving record. That's acceptable to you?
Yes.
Absolutely.
Yes.
Thank you. I think I understand what that means. And
Right.
It means you got away free.
What it means is this is going to cost money, but it's going to vanish. It won't appear on your record, and it won't cause any points. So the sanction for impeding traffic is $175. That's payable through the court's pay portal, or you may walk a cash check or charge into the 44th District Court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's going to be due within 14 days. The court has one related question.
Why'd you
Is
do
a
it?
Preston Swigart a relation of yours?
Yes.
Uh-oh.
Okay. How does that work? Are you his sister?
Are you talking about either my son is Preston and my brother-in-law is a Preston Swigert as well? Are you talking about the elder one?
He's about 6'7", plays the bass.
Yes. That's
Okay.
him.
We miss him. Tell him the Calcutta Rugs, give him his due.
I know the band's name. Yes, I
Okay.
do.
All right. You
Small
take care
world.
now.
I have one question though. How is this different than the civil infraction? Because I didn't mind paying, but then when I went to the court, they said that it would end up.
It doesn't key in. It doesn't
Okay.
abstract to Lansing. That's how it's different. Okay.
Okay, that
All
makes
right.
sense.
Thank you.
I
Take
really
care.
appreciate it.
Bye.
Thank you so much.
Judge is like,
Bye.
leave now.
Bye.
Leave now. Oh.
Okay.
Send back our bass player is what we want.
Do you have language line yet?
I thought that was funny. I saw that one going down. This has happened like
Not yet?
2 minutes
Okay.
ago. So
That's good. They hung up? You're doing fine.
Judge giving words of advice to his clerk who is struggling to get key components in place for court to
This
proceed.
is case number 24B like Berkeley E04176. It is people of the city of Berkeley versus Christopher Allen Arnold. That's you?
That's correct, Your Honor.
Mr. Arnold, welcome. You've probably had the benefit of some context from Mr. Westmoreland, but this is your informal hearing. It's civil in nature. It is not criminal. Nobody goes to jail today on this parking ticket, but it's considered serious enough that Sergeant Smith issued the citation on the date in question, which was October the 16th of this year at about 12 minutes of 8 in the morning. A 2017 GMC gray in color was parked in a prohibited handicap space without a placard at Oakshire and Morrison. So the citation before the court is prohibited parking. As to that, you may admit responsibility in the matter. You can admit and explain, or you can deny responsibility and we'll swear the parties and take testimony. What would you like the court to do for you?
I'd like to admit and explain.
Very well. So you're confirming to the court that a vehicle plated to you or a member of your household was parked as indicated in a handicap space without a proper placard, correct?
That's accurate.
Thank you. What would you like the court to know, Mr. Arnold?
Your Honor, I recognize that what I did was in violation of the law. This happened right outside of Patton Gill Elementary School. I was dropping my son off. Just to add some context to it, I was running late for work. I dropped him off early to go for breakfast. None of that, makes it okay what I did. I pulled in and I have child safety locks, so I walked around to get him out. And then I got back in my car. So it's not like I ran in there, but I recognize that even pulling into that space is illegal. I don't know that I fully recognized that at the time. I clearly do at this point. So I'm a disabled veteran, but I don't have a placard. So obviously that doesn't help me at all. I would just ask if Sergeant Smith would be willing to knock this down into a warning. I've not done it since, and
It
I will
worked
not
for the
do
last
it ever again, fully understanding this how illegal it is.
Thank you, Mr. Arnold. The court appreciates your remarks and your service to your country. This is a parking matter. It's non-moving, so it does not even abstract. Sergeant Smith, do you have anything you want to share?
Your Honor, I gave him a huge break instead of citing for the handicap parking. I just cited for just a simple parking ticket.
Very well. Yeah, the handicap parking ticket is, I think, at least 150. So what the sergeant did was basically write it as if you were a individual parked on the streets of Berkeley during the prohibited time in the morning hours without the proper residential permit. But Mr. Arnold, what the court is going to do is as follows, because it has to respect the separation of powers. The court's going to assess this as if it were an overtime at meter matter. The fine in this case is going to be $20. That's payable through the court's pay portal. or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's going to be due within 14 days. Thank you very much. And yes, those handicap spaces are like kryptonite. Just don't even think about it. Okay?
Understood. Won't happen again. Thank you very much.
You will.
Man, everyone gets a break. He got one break and then he gets another break. Too many breaks. Who's breathing in the microphone like Darth Vader?
Oh, yes. All right, Mr. Parent, we are undertaking a matter that requires a translator, so we'll be right with you. Thank you for your patience.
I think it's the translator. Somebody is breathing.
Good afternoon. Individual from Language Line, can you identify yourself, please?
Hello?
Thank you for calling Language Line Solutions. This is Kelsey, ID 417331, and I'll be your Arabic interpreter today.
Thank you very much.
It's Kelsey. I'm blaming her.
Kelsey, I don't know if you can see him, but you'll be assisting Mohammed El Verik, and you will be assisting him in translating English to Arabic and Arabic to English, correct?
This is correct, and I cannot see him, Your Honor. I'm on a phone call.
Understood.
My phone does not have a
So this is case
screen.
number 24B like Berkeley E04012, People versus Mohammed El Verik.
أنا سأكون المترجمة اليوم. الآن رقم القضية 24 B E 044012 وذلك الناس ضد محمد سري.
نعم نسمعك.
Yes, I can hear you.
So Mr. El Verik can hear you, Kelsey?
This is the interpreter. He confirmed that he can hear me.
Very well. The citation before the court is an informal matter, and it is civil in nature. It is not criminal. No matter what occurs today, Mr. El Verik is not at risk of jail.
الآن هذا الوضع هو وضع غير رسمي فهذه أمر اجتماعي عفوا أمر مدني وليس أمر جنائي فأي ما سيحدث بهذه القاعة اليوم لن يتم السجن.
However, the citation is serious and does state that on October the 5th of this year, Mr. El Verik was operating a 2011 Toyota, white in color, on 12 Mile Road at or near Tyler in the city of Berkeley.
This is the interpreter. May you please repeat after 12 Mile Road?
Say that again, Kelsey.
You said he was operating a 2011 Toyota white vehicle.
Correct.
And what was after that?
Eastbound 12 Mile Road at or near Tyler Road, city of Berkeley.
الآن لكن القضية اليوم هي قضية خطيرة لأن ب15 من هذه السنة الأستاذ زراء قد كان يقود سيارة 2011 تويوتا بيضاء على ويقود نحو وكان يقود شرقا على 12 رود وأيضا بالقرب من التايلر رود وذلك بمدينة بيرك.
And at that intersection and place and time, he did disobey a traffic signal by entering the intersection after the signal had turned red.
وعلى ذلك التقاطع الطرق بالوقت والزمن الذي تكلمنا به قد قطعت إشارة حمراء فأنت قد قمت بقطع الطريق بينما الإشارة أحمر.
Mr. El Verik has three options with respect to his rights. He can admit responsibility, or he can admit and explain, or he can deny responsibility. We will place the parties under oaths and have a short trial.
فيمكنك لديك ثلاثة خيارات. يمكنك أن تقر بأنك مذنب بهذا الموضوع، يمكنك أن تشرح، أو يمكنك أن ترفض أنك فعلت هذا الموضوع. فبهذا الخيار سوف نذهب لمحاكمة صغيرة.
نعم تسمعني؟
This interpreter who is confirming that I can hear him. نعم يمكنني سماعك.
نعم أنا خطأت، أعترف بخطئي، ولكني أطلب منه السماح لأني قطعت الإشارة. كانت صفراء وأحمرت أنا قبل أن أخرج من تحتها، وخرجت الإشارة حمراء، ولكني كنت من قبل أتكلم. عندي ابن كان مريض وكنت أفكر فيه، وهذا خطأي أنا، وأعتذر عنه ولن يتكرر إن شاء الله.
This is interpreter. I'm sorry. He said a couple things that I did not understand. It was a little muffled, so I'm just going to clarify if that's okay with you, Your Honor.
Sure.
Thank you. عفوا أنت تعترف بخطئك وتطلب السماح لأنك عفوا ما الذي حصل على الإشارة؟ عفوا وقلت أن ابنك مريض.
من قبل أن أخرج كنت موقف في مكان التوقيف وكنت أتكلم، وبعدين ذهبت وأنا كنت أفكر عندي ابن مريض. من قبل كنت أتكلم مع والدته، وهذا هو السبب اللي نسيت الإشارة.
This is hard just over a phone without being able to see their face as well.
Yes. Now,
hard work.
I know that what happened and what I did was wrong.
No, I'm sorry, interpreter. I'm sorry, interpreter, please pause for a moment.
Yes.
What the court is required to do by law is ask Mr. Alvarik how he wishes to plead to the civil infraction. He must pick one of those three options only. He can simply admit, or he can admit and explain, or he can deny responsibility, and we will take testimony under oath. So please identify which of those three options he wishes to go forward with. Thank you.
Okay. الآن عفوا قبل هذا الموضوع يجب أن تعطيني هل تقر بذنبك؟ هل تريد الإقرار والشرح، أو تريد رفض أو نفي هذا الموضوع والذهاب إلى المحاكمة؟
نعم أقر بذنبي. أنا خطأت وأقر بذنبي. نعم أقر بذنبي.
I plead guilty.
Very well. So Mr. Alvarik
No
is
explanation.
admitting that he did in fact disobey a traffic signal on that date, correct?
فأنت تقر بأنك خالفت قوانين السير بذلك اليوم، صح؟
نعم صح والله صح.
Yes, that is correct.
What does Mr. Alvarik want this court to know?
Does get an explanation time.
تريد أن تخبر المحكمة.
أريد أن أدفع المخالفة كلها، وأريد أن يعفوني من النقاط، ولكني لن تتكرر إن شاء الله، لن تكرر الخطأ. أريدهم أن ندفع، يعطوني ثمن المخالفة، ندفع ما يريد أن ندفع ممكن ندفعه، ولكن لا أحتاج النقاط لأن يرفع علي بالشغل. أريد من يسامحوني.
Now I want to say that I would like to pay the fee that I owe, and this mistake is not going to be done again, and I just need a little bit of time to pay off the amount. And please don't give me points because I can't afford the raise of the insurance. And this is interpreter, Your Honor, just before we complete. I didn't know if he knew that I did not interpret what he said before that, because that he was explaining what happened.
Okay. Ask him if there's anything else he wants the court to know.
وهل تريد إضافة أي شيء أن تعلم المحكمة بأي شيء آخر؟
لا.
No.
That sounds like no. Okay, Mr. Alvarique needs to know that this court obeys the separation of powers and is sitting as an umpire, and therefore the court can't alter the points, but the court welcomes the input from law enforcement.
This is interpreter. And what did you say? Can't alter the point?
The court can't alter the points. The court doesn't have the legal authority to do that, but the court is happy to hear from the officer.
الآن نحن هنا بالمحكمة لا يمكننا تغيير النقاط، لكن نحن سعيدين باستماع إلى ضابط المحكمة.
Sergeant Smith, would you like to render some form of a rescue?
I would, Your Honor, if I could just make a motion to amend this to impeding traffic.
Okay. Motion to amend to impeding traffic, which is 0 points. Granted.
الآن المخالفة ستكون 0 نقاط.
Fine is $175.
الرسوم ستكون $175.
28 days to pay.
ولديك 28 يوم لتدفعها.
He can pay online.
يمكنك الدفع عبر الإنترنت.
Or he can walk the funds into the courthouse any business day between 8:30 and 4:30 on 11 Mile Road.
قلت عندي كم؟ 28 يوم.
لديك 28 يوم على الدفع. يمكنك أن تدفعهم عبر الإنترنت، أو يمكنك أن الدخول إلى القاعة المحكمة.
ممكن أدفع الآن.
This is the interpreter. I didn't finish interpretation. Can I pay it now?
You sure can.
يمكنك.
نعم، أنا عندي بطاقتي البنكية راح أدفع.
Just read off your credit card number.
Yes, I have my bank card and I can pay it now.
Okay, so he's right here today. He can pay it straight away. Thank you, interpreter. You've done a great job. Thank you, Mohammed.
Thank you.
فأنت هنا اليوم فيمكنك الدفع اليوم. You're welcome, Your Honor. Thank you for using our services.
Take care.
175.
175.
175.
175.
Downstairs.
Yeah.
Yep, you gotta go downstairs.
Thank you.
Thank
Is there anything else I can help you with, Your Honor?
You're all set, Kelsey.
Like,
thank
I'm
you for your
done.
help.
Out of here.
Thank you for using our services. Bye-bye.
Bye-bye.
All right. Language services out of the way.
Thank you, Sergeant.
Oh, no problem.
Mr. Parent, case number 24, Be
Parent
like Berkeley,
Patrick.
E03700. This is people of the city of Berkeley versus Patrick Michael Parent. Mr. Parent, you were present earlier when the court explained the informal hearing process, correct?
Correct.
And the court explained that you'd be required to make a selection from one of 3 options. True?
True.
Thank you. Mr. Parent, the citation before the court indicates that on September the 17th this year at about 6:30 in the evening, you were operating a 2020 Kia, silver in color, eastbound 11 Mile Road at or near Coolidge Highway in the city of Berkeley. And at that place and time, you disobeyed a traffic signal. Sergeant Smith's remarks, which appear on your ticket, indicate took off through intersection while the light was red with patrol alongside at intersection. So that's simply the remark.
Guys, we
the
get a dash
citation,
cam.
sir, is
We get
disobey
dash
traffic
cam.
signal. You may admit responsibility in this matter. You can admit and explain, or you can deny responsibility, and we will take testimony. What would you like the court to do?
Actually, I would like to deny responsibility.
That is your right and your privilege. Please raise your right hands, John. You both solemnly swear the testimony you shall give before this court shall be the truth, so help you God.
I do.
I do.
Thank you very much. Officer has the burden. Sergeant, please proceed.
Your Honor, on the 17th of September this year, around 6:21 p.m., I was eastbound on 11 Mile at Coolidge at the intersection at a red light. Mr. Parent's vehicle was next to my vehicle. He was in the right lane. I was in the left through lane. He was traveling in a 2020 silver Kia Soul.
It's always a
without
Kia.
warning, Mr. Parent went through the red light while at the intersection. I pursued behind them and pulled them over. And I also had the video pulled up too. I would like to show you.
Very well. You may do so. Go ahead and share the screen.
Can you see it okay, Your Honor?
We see it.
Yep, here we go. I see the red lights. Berkeley Police Department.
Can you see it okay?
Yes.
Okay.
Lights are red, lights are red. And he stops. Lights are still red. Got a turn lane, and he's going. He went through a red. Clear as day. Defendant is like, oh, man, he got me on video.
And that is it, Your Honor. I stopped Mr. Parent. And so actually, before even this intersection, his driving was a little erratic, which kind of gave me notice to his vehicle. And at which point, Mr. Parent stopped on the sidewalk at Berkeley and just east of 11 Mile there, or just right at 11 Mile there. And I made contact and issue a ticket for disobeying the traffic signal.
Is there anything else you would like the court to know, Sergeant?
No, Your Honor.
So if the court could see it clearly, it appears as though once the left turn signal went green and permitted left turn traffic to head north on Coolidge at 11 Mile Road, that appears to have been the momentum that may or may not have caused Mr. Parent to go forward. Is that the way it looks? Okay, thank you very much. You obviously have the right to rebuttal, Sergeant. If you choose to use it, Mr. Parent, what would you like the court to know?
Oh, boy. Yes. I had a GPS going. I'm not familiar with the area. And I was going to a friend's house in Southfield. And yes, the cars from the left, as you can see in the video, pulled me through the light. The cars did stop going north, going the opposite way, but the left hand did turn green. And I was lost. I was going around in circles with a GPS that was stuck. So, yeah, it's all on film. I thought it was green. The cars pulled me in on it. I'm sure everybody has done that.
It's entrapment. It's entrapment.
At one point in your life.
Is there anything else you want the court to know?
Like to change
the plea. The guilty was an explanation.
Yes.
Well,
I don't know what I can do here. I can see it's there. It's there. Trying to keep points off my record. I'm on Social Security. I can give you the whole story, but I know everybody does. I'm not going to do that to you.
Okay. Well, the court can find you as a matter of fact and law responsible, but that's not necessarily going to affect the sanction until we get to that juncture. But the court is convinced that by a preponderance of the evidence that you did, in fact, whether you were drawn or induced by what you saw in your peripheral, you did go through and therefore disobey the traffic signal. So the court does find you responsible. The court would simply note a couple different things. Those lights have to be dealt with gingerly, because when folks are not 100% in the moment, and I mean like a pilot, right?
Understood.
And they see a car moving just out of their periphery, sometimes they think by just mechanical habit, oh, it's time to go. And then you'll see people stop short. It happens every rush hour. The issue becomes once you know that you're not doing the right thing, if it's not too far of a committal, you got to try to rectify the situation. The other issue is, while GPS is super helpful, the best thing to do, especially when we're unfamiliar with the terrain, is to pull over somewhere and consult the GPS. So it sounds like you had a few things.
The GPS was locking up on me.
All right.
A new phone.
Thank you, Mr. Parent. Sergeant Smith, what would you like to share?
Nothing else, Your Honor.
Thank you very much. Mr. Parent, the court must obey the separation of powers in this matter. You have been found responsible. Again, it is not a criminal matter. So disobey signal is $150. That's payable through the pay portal on the court's website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That is due within 7 days. If you wish to take exception to the court's ruling, you can perfect an appeal by filing a cash bond in the amount of $150 within 7. Matter will be placed on the formal hearing docket of the chief judge, and the city of Berkeley would be represented by City Prosecutor Dan Christ. So either as a bond or a fine, $150 within 7, that completes your day. Always be careful. Take care.
Bye.
You didn't get a break. It's because he said he denied. He denied. If he had been more contrite up front and admitted with an explanation, or have maybe asked to see the discovery against him before he went to court. I laugh, but the last time I ran a red light, I did it on a live stream. I've been there. You guys watched it, unfortunately. I pretty sure, I say this, I'm pretty sure that I can count on one hand the number of times I have run a red light. And I say knowingly in that before I went through the intersection fully, I was aware that, I shouldn't have gone. There might be some unknowing ones where I just completely just spaced it. I think I deleted that live on purpose.
Is Magnus Dyke available?
I was not stopped. It was just a live stream.
Yes.
Hey, Magnus. Welcome.
Good afternoon, sir. Is your car stationary?
Yes, I'm parked in the gas station. Yes.
Okay.
It's literally
We don't want
stationary.
anyone putting themselves in harm's way. So this is case number 24B, like Berkeley E03900. It is people of the city of Berkeley versus Magnus Dyke. That's you?
DK, D-I-K-E.
DK. I apologize, Mr. DK.
Thank you.
Mr. DK, I believe you were present earlier when the court was explaining the informal hearing protocol, correct?
Yes, I was.
And the court also explained that you must make a selection from one of 3 options, correct?
Yes.
Very well. On September the 28th, Mr. DK, at about high noon, it was said that you were operating a 2008 Toyota black in color, westbound 11 Mile Road.
High noon?
At or near Bacon in the city of Berkeley. And at that place and time, you were operating your vehicle while simultaneously using a mobile electronic device. Officer, strike that. Sergeant Smith's detailed remark, which appears on your ticket, indicates using an XM add-on radio on the floor in a box not attached to vehicle bracket, crossed into double yellow with patrol in the opposite direction. So in essence, rather than charging improper lane usage or anything else, the officer issued what appears to be a 0-point ticket, which is operating a mobile device. However, with respect to that, you may admit responsibility, you can admit and explain, or you may deny responsibility, and we will swear the parties and take testimony. What would you wish the court
I think
to
radio
do?
on the floor seems believable based on the phone position.
Yeah, I'll take responsibility, but I mean, I explained what happened. I mean, I never.
Well, I mean, I'm sorry, Mr. DK, I don't mean to interrupt you, but I need to take a clean, affirmative plea of some kind before we can go on with any further explanation. So the court is doing everything it can to squeeze every ounce of justice out of the building for you. I need to know if you wish to admit and explain, or if you think you're in the right, deny responsibility and we'll take testimony. What do you want the court to do?
Admit and explain.
Very well. So you were operating a motor vehicle in the city of Berkeley that place and time while simultaneously operating a electronic device, correct?
Yes.
Thank you. The court appreciates and accepts your plea. What do you want the court to know, Mr. DK?
Yeah, I am a post office worker and I'm always on the road. So I thought that was like a kind of a warning situation. Hey, guy, you drifted off this double lane. Don't do that again. Be careful.
I'm a bad post office driver. Is that what he just said?
I mean, that's all I have to say on that. It's just the post office don't really like it when we receive these kind of tickets, because we drive the federal government vehicle, and they want us to stay safe at all the time,
Oh, he was at work.
That's understandable. Mr. DK, the court has no idea what your driving record looks like. And again, the court hastens to add this is a 0-point violation. Is there anything you wish to share, Sergeant Smith?
There is not, Your Honor.
He pulled over the post office truck.
Mr. DK, in light of your candor and honesty, what the court is going to do is reduce that very hefty fine amount, which is usually $220, down to $120. So the fine in this matter is $120. That's payable through the pay portal on the court's website, or you can walk a cash check or charge into the 44th District Court, 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's going to be due within 14 days. That completes your hearing. Always be careful out there.
Okay, thank you. I appreciate your looking out for.
Yeah, he just cut him off. The judge wants to be done.
Right. Individual on the phone ending 5307. What's your name?
Oh, that's me, Judge.
Andrea Graham.
Thank you, Ms. Graham. Calling case number 24, be like Berkeley E03244. This is people of the city of Berkeley versus Andrea Janine Graham. Ms. Graham, I believe you were present earlier when the court explained the informal hearing process, correct?
Yes.
And the court also explained you must select from one of three options related to your own rights, correct?
Correct.
Ms. Graham, the citation before the court indicates that on August the 16th of this year, at about 20 minutes of 1 in the afternoon, you were operating a 2020 Chevrolet black in color, eastbound 12 Mile Road, at or near Greenfield in the city of Berkeley. And at that place and time, you committed the civil infraction of improper lane usage. Sergeant Smith's remarks, which appear on your ticket, state, went eastbound through intersection from the right turn only lane.
Ooh.
Other lanes
give us traffic
shut down and posted due to an arrow board. So the citation is quote unquote improper lane usage. As to that, Ms. Graham, you may admit responsibility. You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take testimony. What do you wish the court to do?
Deny again.
Admit with responsibility.
Okay. So you want to confirm to the court that on the date in question, you were operating a motor vehicle in the city of Berkeley, and at that place and time, you committed the offense of improper lane usage, correct?
Correct.
Thank you. Court appreciates your plea. Ms. Graham, what do you want the court to know?
Well, I was, when I was driving down 12 miles, the city of Berkeley workers, they were in the process of putting, I don't know, barrels or whatever in the lane that I was in. So I had to move over to the right, and they weren't finished. I didn't know that the road was being closed. And I'm sitting at the light and I'm looking at, cars turning down the way I wanted to go. So that was, I don't know, I was in a turning lane. So I didn't know that road was closed, and I didn't really know what they were doing when they were there, because as I was sitting there, they were in the process of putting this up. So I really didn't know that that's what they were doing, closing the road ahead of me. So
the big sign in the street wasn't
when the light
clue.
turned green, I just proceeded to go straight versus turning. And then when I thought about it, I'm like, oh God, that was silly. I mean, I guess I was in the right lane. I should have turned right. but I didn't know that they were in the process of closing that road because cars were turning onto where I was going from Greenfield. They was making a right onto 12 Mile. So I didn't really know that the road was closed because they was in the process of doing
I'm guessing she didn't know.
It's
All right. We're gonna bail on that just for a minute. We've got another one I'm gonna jump to down in Florida. If you give me just 1 second to get it pulled up. 14th Judicial Circuit of Florida. Here we go.
For December 3rd, 2024 at 1:30.
These are
You can
felony
no longer
private
waive
attorney
his
pretrials.
appearance, Mr. Atkinson, because he's subject to random urinalysis, okay?
Yes, Your Honor.
Is he local?
I believe that he is. I'm not 100% sure. I probably check. That's how I see it.
Yeah, so he needs to come.
All right.
Okay. All right, so next one, no waiver of appearance.
Love the glasses.
And what time is that, Your Honor?
1:30 on December the 3rd at 1:30.
I believe that's all that I.
That's all you got? All right.
Maybe excused.
Absolutely. Thank you. Robin, do you want to go next or?
That's not what I had.
That's the only one you had? All right, so you're sticking around just, all right, fair enough. I don't see any other private counsel in the courtroom, so let me start with Mr. Kelly for Mr. Meadows, calling from Mr. Meadows' office. Mr. Kelly, who you got?
I have Terry Roberts, Your Honor. The case number is 24429. I've been in talks with Mr. Gill about the case. He wants some additional time to talk to the lead investigator before he finalizes his filing decision. We've discussed a potential resolution, but he's asked me to pass this to the next pretrial conference next month while he has that conversation.
What says the state?
Objection to that, Judge. There could be additional charges coming. As far as the filing decision in this case, though, I've filed an information.
You've already filed?
Yes.
All right, fair enough. So 12-3 at 1:30 for Terry Roberts. Right, Mr. Kelly? That's what you want?
Sounds good, Your Honor. What time?
Excellent. At 1:30.
What time? 1:30? 12-3 at 1:30?
Yep, December 3rd at 1:30.
Thank you, Your Honor. It was a pleasure seeing you.
Is that all you had?
It is, Your Honor. Thank you.
Excellent. Thank you, Mr. Kelly. Mr. Ramey is next, followed by Ms. Bennett. Mr. Ramey, good afternoon.
Good afternoon again, Your Honor. Russ Ramey on behalf of Zachary Johnson. Case number is 24161. This Miss Jeff Coates case. We had depositions scheduled about a week or so ago. We haven't received the CPT video or report.
Have I signed an order yet?
Yes, ma'am. I talked to Miss Jeff Coate. We canceled the depots because I need those before I do depots. We received both the video and the written report later that day, and we have depositions rescheduled for February the 11th.
All right, so you'd like to come back after that, and what says the state?
Your Honor, we have no objection to that, and it looks like we had sent discovery before that, but it hadn't gotten downloaded, and it may have gone to the Musca address
Muscala,
rather than the other address. Well, actually, everything for Mr. Ramey apparently has to go to all of the addresses, but I don't think we communicated with his private office was the issue.
I gotcha. So ladies, can you tell me what day my private attorney pretrial is in March? I have March 4th, Mr. Ramey at 1:30 for that case.
That'd be great, Your Honor. Thank you.
Okay, fair enough. Who else do you have?
Next case I have, Your Honor, is State versus Robert Smith, 24388. Ms. Jeff goes to the prosecutor on that case. She just made a filing decision on that about a week
Is that
ago.
you? Mr. Smith, hold on, Mr. Ramey. Mr. Smith was here earlier in felony court in the morning. He got notices for the 9 a.m. when we thought he might not have private counsel, and then he got the notice for this. So I was just making sure that this was him. So you're Mr. Smith, correct?
Yes,
Come on up, Mr. Smith. Your attorney can hear you if you talk into the microphone. And if you look on the video, Mr. Ramey is on the left-hand side.
How you
doing, Mr. Ramey?
Good. Sorry we missed each other's calls today. Judge, this case was just filed on by Ms. Jeff Coate. I'm requesting some deposition dates. We did file a waiver of appearance on Mr. Smith's behalf. It is a drug charge. Do you want him in present for every court date for your analysis?
Does the state have any information that he was ordered to be UA'd. I do not have that information readily available, but let me confirm.
Let me pull his first appearance sheet. I don't.
I just don't want to run afoul of your rules, Your Honor.
Your Honor,
No,
it looks like he was first appeared by a judge from another county, and I don't see any reference on that sheet, at least, to.
and we confirm that. So no, you wouldn't be running afoul of anything, Mr. You may enter a waiver of appearance for Mr. Smith in the future if you wish, but I appreciate you making sure that he was here
Yes, ma'am.
today in light of our procedure.
Yes,
And I
ma'am.
know it's hard to find from the court record sometimes whether or not that's been ordered.
And Your Honor, if we could have the March 4th date, I think hopefully we can get the case resolved before that date.
Is there any objection from the state?
There's no objection to that, Your Honor.
All right, so Mr. Smith, your next court date is going to be March the 4th. Between now and then, keep in touch with your attorney. And ladies, you've done it? Perfect. Mr. Smith, what you're signing there is just that you understand that your next court date is March the 4th at 1:30. If your attorney has entered a waiver of your appearance, you do not have to be here in person, but you communicate with him on that. But that's what we're having you sign, is so that you know you have court on that day. Okay?
It was filed yesterday, Your Honor.
Okay, fair enough. We're going to give you a copy of this paperwork, Mr. Smith, and then in the meantime, just keep in touch with your attorney.
Yes, ma'am. Thank you.
Okay, yeah, you're most welcome. And maybe I'll see you on March the 4th, okay?
Okay,
All right,
you.
have a good one.
Yes, ma'am.
Thank you.
The tech
Mr.
issues are
Ramey,
being
who
worked
else
out.
do you have?
We're getting
I
there.
have State versus Kayla Thrash, 23-589. She's present. You know, this is the case.
Mr. Ash, hello, come on up. Let's give her a second while she comes up, Mr. Ramey.
I thought it'd be
Mr. Ash,
spicier
hello.
than what it
Good
is. They're just
afternoon.
basically setting new
Listen
appointments.
carefully to Mr. Ramey, okay?
You know, this is the case that we had some questions about what happened over in Gadsden County where a case was dismissed. We got the Blue Man from that. All we can hear on Blue Man is that the prosecutor moved to dismiss the affidavit of violation, and the court agreed and did that. So other than knowing it was dismissed by the judge, there weren't any reasons placed on the record. And I did ask Miss Thrash to bring with her a letter from orthopedic care regarding her hip injury and her surgery, where the doctor is asking that any community service work between August and October of 24 be excused, but she's available to do community service now. I asked her to bring a copy to give to Miss Jeffcoat. Did you bring that with you, Miss Thrash?
I did. She says she did. He can't hear you if you don't talk loudly into the microphone, okay?
So if we could put this on your December docket, Judge, I'm hoping we can have a resolution by then.
Why don't we give the paperwork to Ms. Jernigan with state probation? And that would be, or Shayla, do you also want it?
I can just take a look at what Ms. Jernigan has.
Okay, perfect. And that way we can review this information. And Ms. Thrash, we're going to have you signed to come back on December the 3rd at 1:30. But we want you to keep in touch with Mr. Ramey between now and then.
Yes, Your Honor.
Okay, and the ladies up here will give you that paperwork to come back.
All right, thank you.
Yes, ma'am. And then we'll give you a copy of it as well. All right, thank you, Ms. Thrash. Does that take care of all your cases, Mr. Ramey?
It does, Your Honor. Always a pleasure being in your court, ma'am.
Always good to see you too. Thank you very much.
Have a great rest of the day. Thank you.
All right, you too. Okay, our next case.
What is our next case? That's a great question. May I ask you to decide the next case? We decided not to go to South Carolina, and it looks like also no on Iowa. Those are the two that are the two others that are really running right now. So we might be just a little bit of court hopping as we wait for our next trial. We are doing a little looking around. Let me actually pull up. I think we were going to talk about some documents for Brian Koberger. If you just give me a second. Let's see, Koberger. There it is, Koberger's latest. This file is massive. It's going to be enormous by the time of the end of this trial. Motion to strike. This is one that was filed about a week ago in Brian Koberger's case, and unfortunately, I can't put it up on the screen yet. I'll be able to on Wednesday. Brian Koberger, for those not familiar with the case, this is a individual who is charged with murdering 4 college students up in Idaho. So it's charged by the state of Idaho up there but the trial has been moved to Ada County instead of Latah County. We're now in Boise instead of the little tiny courthouse that it was originally scheduled in. And so now the latest filing from the defense, from his attorneys, is titled Motion to Strike State's Notice of Intent to Seek Death on Grounds of Means of Execution, which means is a lot of words for they want the death penalty off the table. Hey. I don't know what the next case is yet. We're looking. We've got some ideas with the equipment down in Florida. We're looking at a couple things. We'll see. One of the trials that was coming up, I think there was a plea that was taken on that one, so we'll plan things out. We'll get there. Comes now Brian Koberger, by and through his attorneys of record, and hereby moves this court pursuant to the 5th, 6th, 8th, and 14th Amendments, well, I just about cited all of them, to the United States Constitution and Article 1, Sections 1, 6, 7, 8, and 13 of the Idaho Constitution, and a bunch of other rules, to strike the state's notice of intent to seek death penalty. This motion is made on the grounds that upon a conviction and sentence of death, the process by which Mr. Koberger would be put to death in Idaho violates the 8th and 14th Amendments. All right. As well as, so they're saying the execution method is unconstitutional. You sent me a big say. You sent me something on the burner. Let me look. The method being unconstitutional. We'll get into the breakdown of that here in just a second. They say the issues are the constitutional limits on the manner of execution, the history of executions in Idaho, lethal injection in Idaho is not viable, and the firing squad is not and was never constitutional. So they're saying you can't kill him if you sentence him to death. Idaho, I think, would just say, hold my beer. But we'll see what the issues are specifically. Proceeding with capital murder charges in this case is unconstitutional because executing Mr. Koberger by means of lethal injection or gunshot, as conceived by the Idaho Department of Corrections, would violate his right to be free from cruel and unusual punishment under the 8th Amendment and his right to due process under the 14th Amendment of the United States Constitution. It would also violate his rights under Article 1, Section 6 and 13 of the Idaho Constitution. An execution procedure that involves the unnecessary and wanton infliction of pain violates the 8th Amendment. The 8th Amendment's prohibition is not static, but is responsive to evolving standards of decency and contemporary values concerning the infliction of a challenged sanction. Execution by lethal injection constitutes cruel and unusual punishment. Furthermore, the 14th Amendment guarantees that no person may be deprived of life, liberty, or property without due process of law. A violation of procedural due process requires a showing of 1, constitutionally protected interest in life, liberty, or property, 2, governmental deprivation of that right, and 3, constitutional inadequacy of the challenged procedures affecting the deprivation. A prisoner sentenced to death has a constitutionally protected interest in life that is not extinguished by the conviction and death sentence. The manner of execution is set by the legislature in Idaho, as was amended just last year. The new version of the statute is this. This is Idaho's law on death penalty. Idaho is a death penalty state. This is how it appears on the books. The punishment of death shall be inflicted by continuous the following methods. A. Continuous intravenous administration of a lethal quantity of a substance or substances approved by the Director of Idaho Department of Correction until death is pronounced by a coroner or deputy coroner. That first one, that's a lethal injection. A lethal injection. I'm going to try to pin this one for you, Amber. Hang on one second so you don't have to answer the question a million times. Or B, firing squad. That is literally line up a bunch of people with guns. I think most of them have blanks. One or two have live rounds, and they all shoot at the same time at a little patch taped over, pinned to the heart of the defendant who's sitting in a chair, strapped to a chair. So they literally shoot him simultaneously. And the idea is nobody knows precisely if their gun was actually firing the live round. Okay, those are two versions under the new statute. Not later than 5 days after the issuance of a death warrant, the Director of the Idaho Department of Correction must determine and certify by affidavit to the court that issued the death warrant whether execution by lethal injection, as described in subsection 1A of this section, is available. If the Director certifies that lethal injection is available, the method of execution shall be lethal injection. What that means is our default in Idaho is lethal injection if we can get the drugs that do it. That is a problem nowadays because a lot of the companies that make the drugs that were used for lethal injection don't like the fact that their drugs are used for lethal injection. It's not a good selling point. It's not something you put on the brochure when you're listening. Hey, look what we did. Maker of lethal injection drugs usually is not something that's advertised. So if it's available, he has to say it's available. And if it's available, that is going to be the method. You get the shot. If the Director does not certify that lethal injection is available, fails to file a certification as required pursuant to subsection 2 of this section, or otherwise determines that lethal injection is unavailable, the method of execution shall be firing squad. Okay, this is not the defendant's choice or the convicted's choice in this case. It's if the drugs are available, it's lethal injection. If not, it's the bullet. If a court holds that lethal injection is unconstitutional on its face or as applied, or otherwise determines that firing squad is a constitutionally required method of execution, the method of execution shall be firing squad. So if courts say that lethal injection is cruel and unusual, we'll just use the firing squad. The Director of Idaho Department of Correction shall determine the procedures to be used in any execution, and the provisions of this section shall apply to all executions carried out on and after the effective date of this enactment, irrespective of the date the sentence was imposed, which means you could have had the death sentence issued 15 years ago before this law changed. The law changed. The new law applies to you. It's going to be lethal injection if available or the firing squad. Section 2, an emergency existing therefore, which emergency is hereby declared to exist, this act shall be in full force and effect on and after July 1st, 2023. The Idaho Supreme Court has ruled, this is the attorney continuing from Brian Koberger, has ruled that the word any in what is now subsection 6 refers to each and every person to be executed as an individual rather than a broad policy for all defendants. The court held that because of legal issues with the manner of execution, the Director of the IDOC must provide each individual to be executed with the procedures that will be used in their case in advance of the execution so they may be reviewed and challenged. All right, each death row inmate has to be notified exactly how the state is going to proceed in their particular case so they can then file motions and try to stop it. Thus, one condemned to die in Idaho has no real way to know how they will be killed, at least until the death warrant is issued. Still, as things stand, Idaho has no viable method for killing Mr. Koberger. They know it. They know that the chemicals just are not available. Up until 1978 in Idaho, death was imposed by hanging. 1978. I was one. When they stopped hanging people. The actual structure of hanging was changed more than once because of the difficulty of getting necks to snap as desired, leading to a lack of immediacy of execution. It was faulty. It's like, it's not working the way we intended. Wow. The last man hanged by the people of Idaho was Raymond Snowden on October 18th, 1957. That was well before I was born. as Kathy Hill tells it, here's the, wow. We might have to, no, we can't put this to music. Sorry, Mathis. For the first time, prison officials, this is like a news report, I think. For the first time, prison officials could use their new execution chamber. Located on the second floor of cell block 5 next to death row, the room replaced the outside scaffold used for earlier prison hangings. Throughout the day, guards repeatedly tested the trapdoor to ensure all would be ready for Snowden. The sound of the door dropping reverberated through the cell block. Guards would recall the prisoners were eerily quiet that evening. They could hear them testing the trapdoor. Around 11:45 p.m., prison guards arrived at Snowden's cell. They carried a backboard complete with arm, leg, and foot straps. Snowden balked at first, but with the prison chaplain's assurances, he allowed himself to be strapped in. They delivered him to the execution room and placed him in an upright position. The hangman's noose dangled directly above his head. Approximately 10 people gathered in the observation room, among them Boise Police Chief Frank Demarest and Ada County Sheriff Pat McCarty, who had so deftly built the case against Snowden. Several newspaper reporters were also at the execution, but all declined to enter the observation room. With Snowden in place on the trapdoor, prison warden Lou Clapp asked if he had any final words. Snowden, calm and clear, replied, "I do, but I don't know how to say it." Clapp gave him a few more minutes, then placed a black hood over his head. He stepped back, and the executioner, who received $600 for his trouble, stepped forward. He placed the noose around Snowden's neck, pushed the knot close to his spine, and pulled the trap door. The backboard veered a bit, scraping the side of the trap, but the deed was done. Snowden was pronounced dead at 12:20 a.m., October 18th, 1957. Precisely why Idaho gave up on hanging has no simple explanation. Perhaps the guards telling the stories of the sounds of the trapdoor being tested repeatedly in the presence of the doomed man made people feel uncomfortable with the whole ordeal. Maybe it was the idea of strapping a man onto a board and wheeling him off to kill him with a bag over his face. Whatever it was, the how is relatively simple. In 1978, Idaho's legislature tried to devise ways to kill people that would satisfy the demands of the United States Supreme Court. Senators Jim Risch and Mike Black joined forces to amend the law to require lethal injection. The senators both claimed lethal injection would be more humane. Senate Judiciary and Rules Committee minutes February 16, 1978 have the following. When the bill was proposed to the House Judiciary, Rules and Administration Committee, it says, Warden Anderson appeared in support of the bill by indicating that it was the desire of the Board of Corrections to take the circus atmosphere out of executions. He said there are weird people who show up at executions and contribute to the circus atmosphere. The minutes from February 27, 1978, it's unclear where Warden Anderson was encountering these circus-like executions, given the last one in 1957, as described above, was far from it. However, the new humane method of killing people immediately ran into problems. Bona Miller of the Department of Corrections explained to the House Judiciary Rules and Administration Committee that just 4 years later, as a medical prescription is required to obtain the lethal injection. Then a medical doctor or a medically trained person must administer the injection. The prison officials have been unable to find a medically trained person who would carry out such injections. It might have something to do with the oath, the Hippocratic oath that doctors take, which has something about do no harm in it. Do no harm. They're looking for a doctor who's willing to kill people. Let's see. The minutes from February 19th, 1982, Exhibit C, during that legislative session, as the Department of Corrections and the Idaho Medical Association tried to reach a compromise so that killing could happen, Judiciary Rules and Administration Committee minutes, March 11th, 1982, Exhibit D. The firing squad was included essentially as a backup, and one the drafter of the bill thought was likely unlawful. This was the original birth of the firing squad. In 1982, Idaho law permitted the director to use the firing squad whenever lethal injection was impractical. The only directive provided for the firing squad was that the director would decide its members. The original firing squad, however, never got off a shot. In 2009, the firing squad was repealed with a statement of purpose that read, "The proposed legislation will further amend Idaho Code Section 19-2716 to eliminate death by firing squad as an alternative method of execution. The elimination of the alternative method of death by firing squad is deemed appropriate in light of the United States Supreme Court's opinion in Bays versus Rees, in which the court concluded that a humane lethal injection protocol does not constitute cruel and unusual punishment. There is no similar Supreme Court authority addressing where the firing squad as a method of execution would constitute cruel and unusual punishment in violation of the Eighth Amendment. In addition, Idaho is one of only 2 states that have a firing squad as a method of execution. The rarity of this method of execution could form the basis of an Eighth Amendment claim. Elimination of the firing squad option will allow the state to avoid such challenge. Those were the notes that are included here. Statement of purpose. The reasoning was taken from the statements of then Deputy General Bill Von Tagen and Senior Deputy Attorney General Lamont Anderson, House Judiciary Rules and Administration Minutes from February 11th, 2009. This brings us to this year, where Lamont Anderson, now lead Deputy Attorney General for the Capital Litigation Unit, returned to the legislature to ask for the firing squad back. Senate Judiciary and Rules Committee minutes from 2023 with a PDF link. Mr. Anderson told the Senate Judiciary and Rule Committee that the majority opinion in Glossop versus Gross found that shooting people was relatively quick and painless. And there was an expert opinion in 1983 that said the same thing. The majority in Glossop never referred to the firing squad as quick and painless, except when it quoted Justice Sotomayor's dissent. It seems clear from the opinion in Glossop that the majority was simply pointing out the dissent's view that all methods for execution prior to lethal injection had become unconstitutional, was a distinction from a difference from the view that it was time to simply stop killing people. And no amounts of Google can uncover any experts from 1983 that thought shooting people was humane. In fact, Coleman McCarthy wrote an article called Killing with Kindness in 1983 that would seem to dispel the idea that it was that was the heyday of firing squads. There's a link to a Washington Post article. Idaho does not have the ability to kill a man with an injection at this point in time, and likely will not in the future. This is because of 3 things: a lack of trained medical personnel willing to take life, the difficulty in finding drugs that kill without creating unnecessary pain, and the difficulty of purchasing those drugs that have been held to be appropriate for killing a person by the courts. The United States Constitution prohibits deliberate indifference to the known risks associated with a particular execution method. There are a number of known risks associated with the lethal injection method of execution, and the state of Idaho has typically failed to take adequate measures to ensure against those risks. The Eighth Amendment safeguards nothing less than a human being's dignity and prohibits methods of execution that involve the unnecessary and wanton infliction of pain. Case law, to comply with constitutional requirements, the state must minimize the risk of unnecessary pain and suffering by taking all feasible measures to reduce the risk of error associated with the administration of capital punishment. The state must minimize risks of mistakes in administering capital punishment. More case law. The most recent document detailing how the director would kill a man is Idaho Department of Correction Execution Chemicals Preparation and Administration. It's like the standard operating procedures for death execution. This particular setup was intended for Mr. Pizzuto. This is Idaho's, there's a story titled Idaho Inmate Pizzuto's Execution Canceled. State doesn't have lethal injection chemicals. The court should review the procedures adopted in 2021 the IDOC could not implement. It consisted of 4 different possible methods of death. Method 1 uses sodium pentothal to put the man to sleep and then paralyzes him using pancuronium bromide, and then finally burns him alive from within via potassium chloride. Method 2 uses pentobarbital to put the man to sleep and then murders them with pancuronium bromide and potassium chloride. There's no dispute in the scientific and legal community that potassium chloride and pancuronium bromide are extremely painful if a person receives them while conscious. In Bays versus Rees, the state concluded that failing a proper dose of sodium thiopental that would render the prisoner unconscious, there is a substantial constitutionally unacceptable risk of suffocation from the administration of pancuronium bromide and pain from the injection of potassium chloride. Pancuronium bromide paralyzes the chest wall muscles and diaphragm so that the person can no longer breathe. Potassium chloride causes a cardiac arrhythmia, which results in ineffective pumping of the blood by the heart and ultimately cardiac arrest. The court found the proper administration of the first drug ensures that the prisoner does not experience any pain associated with the paralysis and the cardiac arrest caused by the second and third drugs. The potential pain from the second and third drugs was also acknowledged by the court's opinion in Glossop v. Gross. Additionally, during oral arguments in Glossop, Justice Kagan likened the pain from potassium chloride to being burned alive from the inside. R. Barnes and M. Berman wrote a story, Supreme Court justices hotly debate the use of lethal injection drug. Washington Post as well. Scientific evidence as well as eyewitness accounts from executions established that the death by lethal injection can be extraordinary painful death. Method 2 simply relies on injecting a lot of sodium pentothal. Method 3 is the same idea but relies on injecting pentobarbital, pentobarbital instead. I can't say that word. Pentoarbital. Pentobarbital? Something like that. Problematically, for all these methods, sodium pentothal is no longer available for killing people. The same became true of pentobarbital shortly thereafter. The upshot is that lethal injection does not exist in Idaho at this point in time. The director acknowledged as much in his letter to the Board of Correction in November 2022. Indeed, he was correct. The botched legal injection, I think they mean lethal injection instead of legal injection, found a typo. The botched lethal injection of Thomas Creech on February 28, 2024 demonstrates that even when lethal injection drugs are obtained, lethal injection is not available in Idaho. After 58 minutes and eight attempts, the warden finally halted the execution. Oh my goodness. 58 minutes and 8 attempts. They tried 8 times for an hour? Due to this history, the legislature adopted the firing squad as a possibility in the last legislative session. Now, to address the firing squad. By the way, we're on page 10 of 143. When considering whether the firing squad in its rebirthed iteration is cruel and unusual punishment in violation of the Constitution of both the United States and Idaho, it helps to have an idea of what it will look like. In 2010, Ronnie Lee Gardner volunteered for the firing squad in Utah, the other state with the firing squad. June 18th, 2010, when a prison official opened a curtain to reveal the death chamber to witness early Friday, convicted killer Ronnie Lee Gardner was already strapped to the execution chair. His eyes darted around the room at a prison in Draper, Utah, but he appeared calm, even at peace, witnesses said. There was a stark contrast from a troubled life marred by drugs, sexual abuse, and indiscriminate violence. Asked by a prison official if he wanted to say anything, Gardner responded simply, "I do not. No." A black hood was slipped over his bald head, a small circular target attached over his heart. A barely audible countdown was interrupted by 2 loud bangs in quick succession. It was 12:15 a.m. After a quarter of a century on death row, Gardner, 49, became the first man to die by firing squad in Utah in 14 years. He clenched his fists and then let go, radio talk show host Doug Fabrizio, one of the small group of witnesses, said, and then he clenched it again. A medical examiner checked Gardner's pulse on both sides of his neck. When the black hood was lifted to check Gardner's pupils with a flashlight, his ashen face was briefly revealed. He was pronounced dead at 12:17 a.m. At exactly midnight Friday, the inmate who spent more than half his life behind bars was awakened from a nap for his execution. He was escorted to the nearby execution chamber where he was strapped to a metallic winged chair. He wore a dark prison jumpsuit and no shoes. The chair was raised on a small black platform like a stage. Relatives of his victims and members of the media witnessed the execution in separate rooms nearby. A team of 5 anonymous marksmen, armed with .30 caliber Winchester rifles, standing just 25 feet away behind a brick wall cut with a gun port, aimed their weapons at Gardner's chest. The Utah law enforcement officers volunteered for the assignment. One rifle was loaded with a blank, so no one knew who fired the fatal shot. Gardner repeatedly rubbed his left thumb and forefinger moments before the shooting. The rifles exploded and 4 bullets perforated his heart and lungs. The straps held his head up. A metal tray beneath the chair collected his blood. Sandra Yee, a reporter with KSL-TV in Utah, said Gardner fidgeted even after the barrage of gunfire. When he was shot, some of us weren't sure if he had passed away because we could see movement, she said. He had his fist clenched and we could see his elbow move up and down. Cheryl Worsley, a reporter with KSL News Radio in Utah, described the moments after the execution as disturbing. He moved a little bit, and to some degree, that bothers me, she said. To some degree, that mirrors the last few weeks of his life because he was fighting to stay alive the last few weeks, and that seemed to continue on. Prisoner officials said Gardner spent his final hours sleeping, reading the spy thriller Divine Justice, and watching the Lord of the Rings film trilogy. He also met with his attorneys and his church leader. He appeared relaxed. He had fasted after eating his last requested meal, steak, lobster tail, apple pie, vanilla ice cream, and 7-Up 2 days earlier. He was at peace, his attorney Tyler Ayres told Salt Lake Tribune. He even laughed a few times, and that helped put me at ease. Outside the prison, members of his family, some wearing T-shirts displaying the prisoner number 14873, gathered to pay their respects. They were joined by dozens of death penalty protesters. Around the time of the execution, family members cranked up a car stereo playing Leonard Skinner's Freebird. He did not want nobody to see him get shot, said Gardner's brother, Randy Gardner. I would have liked to be there for him. I love him to death. He's my little brother. Ray Sanchez, Ronnie Lee Gardner, executed by Utah firing squad, was another article for ABC News. Additionally, Utah's Department of Corrections made a commemorative coin to give all the staff that helped kill Ronnie that day. Okay, this seems wrong. This seems just a little wrong. Jeff Lysick, Corrections creating commemorative coin for Ronnie Lee Gardner execution. They gave out like a coin, a collector's coin, a sheriff's coin, but a corrections coin celebrating an execution. That's a little much. That's hard for me to take in at the moment. There's an eerie similarity between the killing of Snowden by hanging in 1957 and the killing of Gardner in 2010. Men forced to spend years on death row, finally taken to be murdered by other men. Men strapped to boards, faces covered by bags, the circus going on outside, and the coins being minted to remember state-sanctioned killing. The court should wonder at why Idaho is choosing to go backward. The answer to that is the claims Lamont Anderson and those in his office suddenly seen the light at the end of the gun barrel after getting rid of the practice almost 15 years ago. Their claims rest on the misreading of Glossop. The majority in Glossop was not considering firing squads as a method for execution. Only the dissent did that, and did so on a bare record. Both majority and dissent were of the opinion that Wilkerson v. State of Utah held that the firing squad was unconstitutional. That simply is not true. Wilkerson did not test the constitutionality of the shooting people as a means of execution. It tested whether a judge in a territory had the authority to order a shooting after the territory removed from its statute the method of execution. The court did mention in dicta that it did not think firing squads were cruel and unusual, but that had nothing to do with the holding. As the court acknowledged, no one was arguing in 1878 that it was cruel or unusual. Had the statute prescribed the mode of executing the sentence, it could have been a duty of the court to follow it, unless the punishment to be inflicted was cruel and unusual, within the meaning of the Eighth Amendment of the Constitution, which is not pretended to be counsel of the prisoner. Since there was no Supreme Court case that has ever actually considered whether it is cruel and unusual to use a firing squad, this court should look at the ruling of the Court of Common Pleas for the Fifth Judicial Circuit of South Carolina in Owen v. Sterling. Although ultimately reversed by the Supreme Court of South Carolina, the court's analysis was sound. So this was reversed. This is funny. They're citing case law that literally got overturned. And they have to admit that, okay? Because it would be improper to make it sound like this case stood. But here's the case law. The Court of Common Pleas found that South Carolina recently brought back the option of the firing squad. The statute had been challenged by people set to be executed. In the order granting injunctive relief to a challenge of method of execution, the court noted that the firing squad had been around for years and was largely unused. Thus, the firing squad is not a new method of execution, and it is an unusual form of punishment. This is so even though firing squads have existed for many years, meaning that it is not a newly created or recently discovered means of execution. Rather, it is a reversion to a historic method of execution that has never before been used by our state and is not used in the overwhelming majority of other states. Thus, execution by firing squad is an unusual punishment both nationally and in South Carolina. Did we get a box? It got smashed beyond recognition. I'm hoping this. It's literally open. I kid you not. This box is open. Here's my camera. I'm hoping the lens mate is still in here. Camera mount. Lens. Sorry, we're taking a break. Making sure I didn't order anything else with this one. I'm missing a cable. Unless it's in here. Oh, got it. It's in there. It's in there. Got everything. It's good. Thank you, buddy. This was supposed to arrive tomorrow, but it arrived today, and it's completely beat up. But the box is in perfect sealed condition, so I'm good with that. Or the outside box is broken. The Lumix, the lens we're going with is a, let's see. I think it's a micro four thirds. Yeah, it's a micro four thirds lens, 14 to 42 millimeter, f3.5 to 5.6 ASPH. It has optical image stabilization, power zoom, and it can remotely. This came via FedEx. So, all right, we were in the middle of reading about the Court of Common Pleas. As I read through this, let me just stop and explain this. No, DHL. It's DHL. I'm excited. Let me take a peek at the lens here really quickly. This is a tiny little lens. It's wrapped up nice and tiny in a little bag, in a bag inside a bag. There it is. It's called a pancake lens, but it does have power zoom. I'm not sure if you can see that. Oh, probably if I hold it like that, it's a little better. It's got power zoom and focus, so I can control it remotely. It's cute. It needed to be small because I'm mounting it on a GoPro mount. That made my day. I'm happy about this. Sorry. I'm not sure if anyone's interested in what we're reading. By a show of vote, do we want to continue looking into this motion to strike from Brian Koberger? This is a Blackmagic Micro Studio Camera 4K G2, the world's smallest Ultra HD broadcast camera with a 12G SDI 4K sensor and cinematic color science. And of course it comes with Blackmagic design stickers, which I have a plethora of. Oh my goodness, it's gorgeous. Oh, look at this. Look at that little camera. that beautiful? And it's got little tiny SDI, so that's why I got the special cable to attach to that. 12G. We're going to mount the lens on here, which I think I'm going to do right now. All right, there's our camera. Lens is mounted. There's no viewfinder on this. It's meant to be mounted in little hard-to-reach spots, like the little corner of my office back here behind me. So it'll sit right back here and look forward and get a much bigger picture, hopefully without this little grainy stuff you see. Oops. Let's see. All this little grainy pattern. It's going to sit right back here, looking down. And I can adjust everything from here. Oh, it's beautiful. Man, it's gorgeous. Blackmagic Design knows how to make a really, really awesome camera. I've never ceased to be amazed by this company. The only thing that would make this particular camera better would have been power over Ethernet. Power supply. All right, so I think we're going to read a little bit more of these, but we're going to take a little bit of a break. I might summarize some of it because we're only 10 pages into 143. Can you set it up now so we can watch you install? I can do that. You look at the adapter cables. Should have another shipment of cables coming today. I've ordered so many cables this week. Okay, so this little custom cable, this little custom cable here, it's a little tiny, well, it's a micro BNC to BNC female, because the camera is so small it can't hold the normal size of connector. And because it's that small, now here comes in the cables we bought yesterday. Right here as well. See if I can just get one of them out without making a mess of everything. Should be a couple feet long. Cables connect together with a locking twist, so they can't come apart. And just because I don't want it being pulled on, I'm going to put another cable on for an extension. The cable I normally use for this is currently down with Trial TV Live in Florida, or the cable I would normally use. We have a lock-in connection. And because this is a hot swappable cable, this cable's much longer than the other one. I'm going to swap that one out. I should be able to just plug this in and go live immediately. We're going to use camera 3 input for this. And I still need to work on the mounts. But now we need power. I need to clean up the desk before I show you the desk as well. Oh, I guess you're already seeing it. Sorry. Okay, I need to switch to this camera because I'm going to be unplugging. Well, I want to do a side-by-side comparison. So let's do this. Let me take a screenshot of what this looks like right here. Give me just a minute. I'm going to take a picture of this right here and compare it to the new camera. So now when I go to this is the screenshot. It's nice and holding still, so it's not moving. You can see the look there. Now we'll go to this camera full, and I'll unplug the other one. Man. I'm not seeing a picture yet, which means I'm probably doing something wrong. It's black. So I need to figure out how to make it work because right now it's not. Okay, so we'll do some troubleshooting on this because I can't figure out how to make it turn on. I think I might have to tell it to connect via the SDI instead of the HDMI, and to do that I might have to hook it up to an HDMI to program it. But yeah, battery's not included. There is a battery pack for it. Hey, Mrs. R.A., welcome. Probably needs to charge. It doesn't have a built-in battery. It has a battery pack on the back. It looks like it turns on just fine, but it's not. It's not sending a signal. All right. Well, let's do this. Let me go to work again on my studio tonight and see if we can make it better for tomorrow. I think I'll also do some rating on the Brian Koberger, see if there's anything spicy in the rest of what's happening. We have the Brian Koberger hearing coming up on Thursday this week up in Idaho. The chair is really squeaking. This chair, I've sat in it for a year and a half, and I put it to work. I really do. We'll figure out this camera here in just a bit. It's not turning off. Okay, it's turned off now. Lens cap, and we're good. All right, we'll get that figured out, and hopefully tomorrow will be better. I have the screenshot saved as what it looks like, which right now you can't see at all. But we can just imagine. We can just imagine that this is me, even though I'm looking off the screen. Oh man, good times, good times. My studio's a mess now, and I need to clean it up. I've got WD-40. I think something needs to be tightened. Something needs to be tightened on this chair because it's rocking more than normally. Like it reclines and it also tips. So I've got two angles of pivot. The lens cap, good. I checked the lens cap. It's good. We'll figure it out. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning. Hopefully a little bit closer to finding our next case, as we're doing a little bit of paperwork and searching in the background to bring you something wonderful that you guys will love. I just can't get into the Burns. The Burns Alive trial is terrible. I think many people who are going to go watch that are going to regret it and leave and look for something else mid-trial. So it's a tough one. Anyway, have a good one. Be good to each other. We've already said the outro, so we'll see you tomorrow morning. Hopefully with new camera working. We'll see you.